was there tension in accommodating conservative elements in the country and pushing for individual liberty?
Well, of course there's a tension. That's why, the work of the Supreme Court is so commented upon and looked at so critically, and all the better for it, because decisions which we are taking will affect the course of our society for the next 50 or 100 years. For instance, should women have the right to pray in Sabrimala? I felt that the right to pray is fundamental. Each one of us, whether somebody may be an atheist and you respect their, their leanings, but you can't exclude women from a place of prayer. And I felt that the fact that a woman is in the menstrual age group of 10 to 50 is no ground to exclude her.
Wonderful and compelling array of conversations we have today, which are in many ways interlinked, because it's a kind of, triple mirror on our collective lives as a society. And first up is the thing that matters the most, the foundational text on which we have all come together, which is the Constitution. How is that given life? How is it held up over 70 years? What is the instruments through which it expresses itself? And of all the four pillars that keep a democracy alive, possibly the spinal cord of it is the judiciary. So it's a particular pleasure and honor to have with us Justice Chandrachud, who has been the Chief Justice of India, but also been an absolutely headline figure in India's legal life for many years. He comes from a pedigreed family of judges and lawyers, but he has put a footprint of his own vision onto our collective lives with some nation-altering verdicts, many of them which have extended the principles of the Constitution in terms of liberty, equality, privacy, individuality, freedom. Some others that have earned him debate and controversy, but he has stood his ground through all of that. He's also expanded the democracy of the judiciary by bringing technology into it, by creating rights for women in the armed forces, for disability. So in many ways, he has really transformed our collective lives. And now he's done something which is unusual, which is that he's put himself out on the public line by writing a book called Why the Constitution Matters, where he reflects on many of his, as I said, nation-altering verdicts, the thinking that went behind it, the reflections that he has now post-retirement. So we're going to delve into all of that. Ladies and gentlemen, please join me in welcoming Justice Chandrachud. Justice Chandrachud, as I said, it's amazing that you've written a book and put yourself out for public discussion. That's an act of courage. And, when in the foreword to your book, you've written that ideas and words have this transformative power. They can reshape imaginations, they can arouse responsibility, they can touch souls. And that's really an impulse that drives this platform. So it's wonderful to have you here.
Thank you very much for inviting me here.
Right. And then there's something else, so I'm going to dive into it, which is that you've said as a judge, every single day you enter an arena of conflict, conflict between government and judiciary, between contending parties, between individuals, even down to the intimate relationships of husbands and wives and children, and that you steady yourself with meditation, So I want to dive into the absolute foundational struggle and conflict there is, which is about jurisdiction itself. Between the government and the judiciary, there's been great debate about who is the real arbiter of India's public life and the Constitution. There's always talk of judicial overreach. The Vice President, who of course now has himself left, said that it's not the judiciary, you're unelected. So where do you stand on this big debate?
Well, actually, it'd be foolhardy for me to assert that the judiciary is the most important of the three organs of the state more important than the legislature or the executive.
Okay.
Plainly, the judiciary does not have the power to enact law. The judiciary cannot raise finances. The judiciary cannot decide when to go to war or when to get into peace after war. So, all the three wings of the state, of the constitution, have a function of their own. The judiciary has a specific function to test the validity of legislation, to test the validity of governmental decisions when those decisions are challenged. And while doing so, also tell yourself constantly that we live by the separation of powers, that in a democracy, so much is entrusted to the other wings of government. So long as we apply clear constitutional yardsticks of what lies within the realm of the judiciary and that policy area which lies beyond, I think, we have our work set
So
for
Justice,
us.
can you just to give this life, could you pick maybe two incidents, where there has been debate and where you might concede that yes, that was judicial overreach, it was in an ambiguous zone, and where you feel the government was pushing back on you, but you think the judiciary was well within its rights to assert itself over the legislature?
Let me give you the example which is, more in favor of the judiciary because that's where I originally belonged to. During the COVID times, the government was not sure on whether it's going to distribute free COVID vaccines. They were initially banking on the private sector, CSR initiatives to fund the COVID vaccination program. The case came up to the Supreme Court. It was, in fact, a suo motu assumption of jurisdiction, which is that we ourselves had decided to intervene and take it up. And we told the government that, look, you have to smell the coffee. Those were the words which we used. And we said that when we are confronted with this gigantic challenge to our very existence, the government can't just step back and say that, particularly in a society like ours, a poor society, where you have sections of the population which wouldn't be able to afford the vaccine, you can't tell people that you have to go and spend your own money. We said that you can take the credit for it. If you don't do it, we are going to order the government to do it. And the government came back and said, yes, we're going to distribute vaccines free. And you know what happened thereafter. I mean, it's been a success story.
Right. So there, Justice, not the impulse of it is absolutely clear, and like it would inevitably earn you a clap, but in the pure narrow dominion of judiciary versus legislative, do you think that that then just, it's like an individual subjective response that yes, this should be done, but it really actually falls in the realm of legislature? And why I was asking you this is because I was going to ask you about suo motu, the subjective thing of taking a suo motu notice later into our conversation, but since you brought it up, there'll be so many other incidents where people will feel the court should take a suo motu position and it doesn't. So does this fall in the realm of subjectivity?
Well, I'll answer the latter part of your question first, which is the assumption of jurisdiction by the court on its own accord. That's what we call the suo motu exercise of jurisdiction. I remember as a young judge of the Supreme Court, I read about horrendous rape which had taken place in one of the states, and I went to the Chief Justice and I said, Chief, we have to do something about this. And he said, you're right, this is a very serious issue. The question is whether the Supreme Court should be taking it up, because you'll find every single day in the newspapers something worthy of the Supreme Court taking up the issue. Now, would we become dysfunctional by assuming, control over too many things which are not really meant for us? Or you have the high courts, which are the first line after the district judiciary. So, the assumption of suo motu jurisdiction is, again, a very vexed issue, because there are 100 good things that are happening in society, and there are 100 bad things which you see around you. Does the court go in and sort of attack every one of those problems? If you start doing too much of a good thing, you realize that, you are spreading yourself too thin, because at the end of it, you are 34 judges. And then you are open to the charge as an institution that you are virtually taking over the governance of the country. Yeah. And that's the danger, because if judges try and take over the governance of the country, A, you don't have the political accountability which, say, Parliament or your state governments or the central government have to their legislatures, to the people at large. So by and large, you have to draw the line and take up those issues which are of critical national importance, one. And second, keep yourself isolated from issues of policy. Now, I'll give you a basic issue of policy. How much foreign direct investment should you have in a particular sector? Not a matter for the government.
That's clearly not. That's too easy. I'm not going to let you get away with that.
Now,
how about
I'll give you something more difficult. I'll tell you we have something more difficult. Should you allow crackers over Diwali? Should you not allow crackers over Diwali? At a certain level, it implicates your right to life because, you know, the quality of the air which we breathe directly impacts on our right to life. But then, because so much of this turns on science and a very detailed assessment of how science interacts with, you know, our environment, should this decision be entrusted to more technically qualified arms of the state? I have no clear answer to this.
Right.
Our courts do interfere, our courts do step in because we believe that we have a constitutional mandate to interfere.
Right.
But again, while we do step in to, you know, protect public health, for instance, equally we are conscious of the fact that perhaps this is not the most perfect form of intervention.
Right.
But if nobody is doing something, obviously the courts have to do something. So
I'll come back to some of the suo motu cases where there's been a lot of public discussion about why the courts are not stepping in. But first, I want to come back to this struggle for power between the legislative and the judiciary. The other very big debate in public life is over the basic structure of the Constitution, you know. And particularly, say, under this dispensation, there's been argument that, you know, there have been more than 100 amendments of the Constitution, and that if indeed there's legislative strength, then you can review the Constitution because it's your right to do that. That is the elected right to do. Where do you stand on that debate about the basic structure of the Constitution, and which is the cutoff date at which it becomes the basic structure?
Let's be very clear about this, that the basic structure of
Sorry, will you talk into the mic?
Yeah, the basic structure doctrine was the savior of our democracy in the 1970s, particularly when there was an aggrandizement of power. And this was one signal doctrine which ensured that Parliament's power to amend the Constitution is not unlimited. For instance, in 1975, when Mrs. Gandhi responded to her election being unseated by saying all disputes about the election to the office of the President, Vice President, and Prime Minister will not go to the normal courts, that was the 39th Amendment, it was struck down by the Supreme Court. So the basic structure doctrine has in that sense been a North Star. The former Vice President found a problem with my use of the expression North Star, but I still assert that it's been the North Star. But look at it this way.
Now he's probably wishing that the Supreme Court could step in on his troubles.
And you know, Shoma, look at it this way. Notwithstanding the basic structure doctrine, our courts have not been trigger happy. The basic structure doctrine has not been used to invalidate constitutional amendments at random, because courts are conscious of the fact that the legislators, Parliament and the state legislatures, are elected by the people in a democracy. And what they do is entitled to some deference or presumption of constitutionality, as we say. So it's not that, you know, the courts are, you know, very keen to strike down constitutional amendments. But the very fact that there is this power in the court exercises a degree of restraint.
So let me specifically, and now we'll shift to some of your judgments, but you know, the specific question of secularism, because it was introduced into the Constitution later, it's not part of the founding document, and that's probably where the big debate hinges, you know. So what do you think about that particular debate?
The word secularism, as you rightly said, came in as a result of the 42nd Amendment during the years of the emergency, where, you know, the word was specifically introduced into the preamble. Now, the preamble is not directly enforceable in a court. It broadly gives you the objectives of democracy,
but it's the bulwark of the Constitution. Yeah.
But if you ask me, I feel that the word that was introduced by the 42nd Amendment only made clear what was implicit in the Constitution right at the beginning. Our Constitution guarantees to every citizen the right to freely profess, practice, and propagate religion. It guarantees to each one of us as citizens the freedom of conscience. Now, it mandates an equality of faiths. Now, if these are the fundamental principles which the Constitution has brought in at the very birth of the inception of the Constitution, then the insertion of the word secularism at a later date really didn't make a difference, except that it made it more clear. But to my mind, even in the absence of that word, our Constitution mandates an equality of faiths, it mandates equal respect for all religions, and it mandates at an individual level the freedom to profess and practice your own religion. So to my mind, that word is not something which is radical. It didn't introduce a radical idea. That idea of the fundamental equality, which is implicit in the equality provision of the Constitution, was always there at the inception.
So, you know, Justice, you've done so many important cases that I was thinking, how do I kind of actually give a run of, you know, all the all the judicial ideas that have driven your term in office. So I was thinking of two lenses on it, you know. One is that as the Chief Justice, and as I guess any judge, occupies a high seat, you know, and then there's also the hot seat of really being a judge. So I want to look at the high seat and the hot seat. In the high seat, it's very clear there's consensus, you know, you've been applauded for the privacy judgment, for writing down I won't say there's consensus. The liberal end of the country would be happy that you wrote down 377, you know, you decriminalized homosexuality, you shot down the electoral bonds. You know, there are many, you've shot down the idea of adultery, particularly female adultery. You created equal access into the Sabrimala temple. So these are things where, you know, it's extended the liberal values of the Constitution. But I wanted to ask you that in every society, there's a conservative element, and then there's the idea of individual liberties. And there's always a tension in this in society. When you're adjudicating, and you've said the Constitution is a living document, not just principles, but a lived experience, are you in a dilemma about these things? What was your reflection when you were making these judgments, and was there tension in accommodating conservative elements in the country and pushing for individual liberty?
Well, of course there's a tension. That's why, you know, the work of the Supreme Court is so commented upon and looked at so critically, and all the better for it, because decisions which we are taking and we are taking will affect the course of our society for the next 50 or 100 years. For instance, should women have the right to pray in Sabrimala? I felt that the right to pray is fundamental. Each one of us, whether somebody may be an atheist and you respect their, you know, their leanings, but you can't exclude women from a place of prayer. And I felt that the fact that a woman is in the menstrual age group of 10 to 50 is no ground to exclude her. Obviously, there are two views on these issues. One of my own very distinguished colleagues, who happened to be a woman herself, dissented. So obviously, there are two viewpoints in most of these cases which you are deciding. While we decriminalized homosexuality, when it came to marriage equality, and if we have time, we'll possibly go into it as well, we felt that we couldn't do something which was essentially entrusted to Parliament, because our law speaks of marriage between man and woman, the Special Marriage Act. And we could not read that as a marriage between man and woman, which would amount to rewriting the law, right? But on a portion of it, I was again in a dissent, because I said we must still recognize the right to form civil unions. I was in a dissent on that, you know, 2 of us against 3. So a lot of these issues which we are constantly debating do give rise to differences of opinion, differences of perspective, because at the end of it, you know, it's about our vision of what a just, humane, and compassionate society should be all about. And the fact that there is a difference of opinion, I think, is important and critical to democracy, because that shows that the democratic culture is alive and thriving in the country. I would be very fearful everybody sort of said, oh, this is great. There have to be voices which are counter-majoritarian and counter-court as well, because, you know, people who express different perspectives, critique your role, and all the better. Sometimes you find it's not well taken. There is, especially in the age of social media, that, you know, you are criticized for something which you didn't say, or something which has been misinterpreted. But that's all right. That's a product of the age.
Right. Some of that we're going to discuss. But just staying with this idea a little bit more, there's this idea of individual liberty being the bulwark of the Constitution. You know, that's really the fundamental principles on which we have come together. But there are times when you're extending that, when there's a whiplash in society as well, you know. So is there any time when you have felt that on principle you may have done something further, but you have curtailed yourself because even as a judiciary, and like you said, it's a lived experience, it's still reflecting, you know, updating itself constantly with society, and so you may have deferred something for another time because society is not ready for it. So would you be frank enough to tell us about a dilemma like that?
You know, the Constitution is basically a social transformative document. When it was born, when the Constitution was adopted in 1950, the effort was to make a society which was caste-ridden, patriarchal, hierarchical, you know, more equal. And courts are an integral part of that process. Courts have been ahead of the curve in that process of social transformation, whether it's in terms of redefining what you mean by merit when it comes to, say, reservations for the scheduled castes and scheduled tribes, when it comes to gender. The government, for instance, was urging before us in the armed forces case that, well, we don't have toilets for women in the Russian-built warships. So we said, too bad, you have to just make those toilets, but we can't therefore exclude women. So we have been ahead of the curve in most areas. But at times you do realize that, well, you can't get too far ahead of the curve to a point where you break the legitimacy of the court, because you're carrying not just the burden of interpreting the Constitution, but also making the work which you do affect ground-level reality. There's no point in, you know, just abstract reiterations of principle by the court if it's not going to make a difference to society on the ground. And that really is the real craft of judging. Where do you draw the balance? How far do you go? And these are matters which cause sleepless nights. You're constantly you know, involved in a dialogue with yourself, with other colleagues on the bench. That's why so many of these cases have, say, 5 judges, the Constitution benches, and 5 judges who come from different backgrounds, different states, different cultures, different language traditions, different lived realities. For instance, colleagues who've been women. The reason why you have more women on the bench is not because you will necessarily have more liberal outcomes. That's not the reason. But just because women have different lived realities than men as a part of any society. So having this diversity of viewpoint in the court adds to a better decision-making process.
But, you know, so in that, just very quickly on the civil union factor, you know, because you were seen as a judge that wrote down something that the government was really resisting, which was decriminalizing homosexuality. Do you not think that it would have, I understand the point you're making about, especially the idea of marriage is very sacrosanct socially, and then pushing that may have been, like you said, that one step too far. But how about that opportunity then to urge or to you know, to pass a judgment that says you have a right to civil union? So it's a different language. It doesn't impinge on the majority of society, but a civil union would have pushed it much further.
Oh, I completely agree with you. For instance, the government argued before us that there is no bar to 2 people who are in a queer relationship, an LGBTQ plus couple, actually having and living in a union. It's no longer criminal. So 2 people who are 2 men or 2 women can be in a civil union. But the point is that unless we recognize it, you don't have that sense of legal, the constitutional status. Or take the case of adoption. You know, a single woman can adopt a child. A single man can adopt a child, but a single man cannot adopt a girl child for a variety of reasons. Now, if a couple comes together, you have a lesbian couple, or if you have a gay couple, each of them can adopt a child. But together they cannot be treated as parents of the child. So in my minority judgment, I said this is plainly discriminatory. And you must recognize joint parenting as part of this process of civil unions. Again, we were in a minority. 3 of our colleagues felt that we were stretching the line, and perhaps that's something which Parliament should do. I hope that someday the law will change, because in that sense, dissents speak to the future.
Yeah.
And that's why dissents,
No, and
I feel, are
I
so
think
valuable.
again one of the judgments that came as a relief to society was the judgment on the electoral bonds, you know, because that had made electoral funding and political funding so opaque that that was, you know, really one for the ages that you did. I just want to come to some, you know, you've used the idea of the Constitution also being a living document, and that is not just in the courts, but in public conversations like this, in classrooms, and, you know, that there should be discussion about it. So even though you have retired, I wanted your opinion on something which is very, very important right now, which is that there was a senior advocate that tried to throw a shoe at the Chief Justice, you know, and because of a comment he made on Lord Vishnu. And the response to that has been very bewildering, because whereas the Supreme Court Law Bar Association has been asking for punishment of this advocate, the Supreme Court judges, you know, have said, let's not rake up this issue too much. The Solicitor General Tushar Mehta himself has said, oh, let's just keep this quiet and let it die a quiet death. And I want to put to you that if that had not been Rakesh Kishore, if it had been a Dalit, if it had been a Muslim who said that my idea of religion has been harmed by what the judge said, and he threw a shoe at the Chief Justice, would the response have been the same? So this is playing out in a court that you have just vacated. What is your opinion on it, and does it trouble you? Why is there not criminal contempt on him?
You know, what happened that day in the court was extraordinarily serious. When someone throws a shoe at any judge, it could be a district judge, leave alone the Chief Justice of India, it's an extraordinarily serious affront to the institution of justice. It's not about, you know, the nature of the weapon you used or the nature of the assault, but this is something like contempt in the face of the court, because it is an affront to the very legitimacy of the institution. So as a citizen now, I'm not talking about it as a judge. As a citizen now, I think that it deserved serious treatment. Now, I also understand why the Supreme Court decided not to take serious action. And then I'll answer the third part of your question. There is a perception among judges that the power to punish for contempt must be wielded with the greatest caution. For instance, when someone is critical, I mean, there was a stand-up comedian who said something, you know, prima facie derogatory about the court. The point of the matter is you don't chase people around in that case for the expression of views, even though it may appear to be very stringent, very caustic. Now, the other problem with the contempt jurisdiction is that as judges, you are deciding on a contempt of yourselves, and therefore judges traditionally and for valid reasons exercise a degree of restraint when you exercise the contempt jurisdiction. In this case, the Chief Justice of India himself said in open court that, well, I want this chapter to be closed. I don't want someone to be a martyr in my cause. Now, I think that was entitled to respect, and that's what weighed with the court in ultimately closing the contempt proceedings. Because something that you see, Shoma, is that giving these sort of cases more traction only adds to the prominence of the issue. And so often, giving prominence to the issue is exactly what is desired by the person who is doing that particular act.
Sure.
And the last part of your question, should it merit the same treatment irrespective of who the violator is? To my mind, absolutely. The religion of the person who is doing it, the nature of the views, whether it's a stand-up comedian, it's someone who is expressing a view critical to the court in a political commentary, should make no difference. Once you take a particular yardstick, it must be applied across the board. Don't make any discrimination then.
No, absolutely. That is absolutely and uncontrovertibly the theoretical position, but I was asking in the context of our conversation earlier that is there sometimes a worrying accommodation of, you know, like a dominant mood in society. So because this is a Sanatani lawyer, he gets a differential treatment to if it had been a Muslim lawyer or a Dalit lawyer who's angered by something and throws a shoe. I can't imagine a situation where the Solicitor General, if it had been a Muslim and throws a shoe at the judge, where we say, let's keep this quiet and let it be. And why I'm particularly picking on this is not to, communalize the issue, but I was surprised because the Supreme Court Bar Association was specifically arguing that this is an assault on the institution. Justice Gawai may be elevated and enlightened enough not to personally go after it, but the institution needs to go after it because you've made an affront on the institution. And the Bar Association was being dissuaded from doing this, so that's why I thought it really deserves your attention.
My view is very, very clear that this was a very serious attempt to affect or erode the legitimacy of the court. And you don't have to agree with what the Chief Justice said in order to penalize the response to what he said,
Exactly.
which was not proper. What punishment to give to someone is again, a matter of your discretion. You may sentence that person to just fine under the Contempt of Court Act. You might just sentence him to imprisonment until the rising of the court, which basically means that the person sits at the back of the court till the court rises, or spends that day
But
in
something
a
symbolic
lockup.
at least.
But something symbolic is to my mind, very important in these. I wouldn't like to comment on your part on the Solicitor General, but I must also tell you something which, perhaps doesn't make the headlines. During the course of a day's work in the court, you have different people who come before you, and that was my experience as well. Somebody who is subjected to very grave injustice, a Dalit, as you said, somebody whose rights have been violated. They come and sometimes use language which is not really befitting the court as a very somber, as a dignified institution. They say something very personal to you as a judge. You go back home and you feel terrible about the fact that something like that was said. But you let that moment pass.
Right.
And my own personal philosophy was that stand back from the arena of conflict and let that moment pass. When I was a young person, a young lawyer, I'd gone to visit a surgeon, and he said, "Son, look at the board behind me," and says, "This too shall pass." And I've always felt that there's a lot of merit in applying that dictum to the work which we do as lawyers, judges. Right. Let the moment pass, because things which seem to be very important at that particular point of time cease to have that kind of prominence, maybe just if you step back and go and have a cup of tea over lunch and reflect on things. So it's better always not to sort of be reactive and, be trigger happy. I think as judges, you must have the ability to absorb things. Don't we absorb those things in a family?
Right.
Children say something which is sometimes, a little harsh. A brother may say that, or a sister may say that, or your spouse says that, your partner says that, a friend says that, and we absorb it. That's part of the human process of judging in life.
Right. So I'm steering the car towards the hotter waters, Justice Chaudhury. And again, before we go into some of the judgments which has, triggered public debate and discussion, I wanted to have your view on one or two other important things which are happening right now. One is, and I'm not sure how familiar the audience is with this whistleblower called Sanjeev Chaturvedi, who's a forest officer, and he's part of the cadres. And 16 judges have recused themselves from his cases without reason. I think just one said that he had some prior family association, but 16 judges have recused themselves. Here is an individual who is not getting access to justice because the judges themselves are not hearing his case. Again, is that something that bothers you? And it was happening even under your jurisdiction. Is that not something, again, which requires a suo motu attention?
The duty of a judge also extends to not hearing cases where you feel that you have a personal interest in the outcome of the case. It could be because you had been associated with that litigant when you were a lawyer. It could be because you know someone.
No, of course, those conflict principles are clear.
And the thing is, you never ask judges why you're accusing, because sometimes the reasons for accusal may be extraordinarily personal, and you therefore trust judges.
Could they be fear?
Sorry?
Could they be fear?
No, I don't think that's not my experience. It's not at all fear. But there is a point where you find that someone is not getting an expeditious access to justice by repeated refusals. And there I feel the litigant must have a remedy. Because if judge after judge in a court is not willing to take up the case, it can't be that therefore the person for, say, 16 weeks doesn't get a hearing.
It's been many years
Right,
actually
absolutely.
that he has.
So then I believe that the Supreme Court must step in at the behest of that particular litigant and say, all right, if by and large the judges are not hearing it, we request the Chief Justice of the High Court to either assign, verify in advance from a particular judge whether they are conflicted, whether they are going to hear it, submit a report back to us. If no judge of that High Court is willing to hear the case, we'll transfer it to another High Court. Now with video conferencing and all the technology, it's as simple as that. You could be heard in any other part of the country and get an effective hearing. But I'm absolutely in agreement with you that, where there are repeated refusals of judges to hear cases. Now, what do you mean by repeated refusals? If 2 or 3 judges don't hear a case, that doesn't mean that it has to go to another High Court. But where you find that this is now affecting a citizen's right to expeditious relief from a court, especially when personal liberty is involved, someone is in jail, somebody is applying for bail, you can't have a situation where judges just sort of pass on the buck and say, well, I can't hear the matter. Somebody has to take do the hard talk and take up the case and deal with it.
So, Justice, just 2 more which are in the current conversation, and then we'll come back to some of these really sort of historic verdicts that you've made. The 2 again which are in common discussion, one of course is the case of Umar Khalid, because he's been in jail for 5 years without bail, and it's not that he's a threat to, he's not like a known terrorist, known criminal records. So what do you feel in that case? And I know that you publicly said that his own side asked for many adjournments, but you were not the judge on the case. And to whatever I'm no longer on a day-to-day journalism, but from what I've read, even that assertion wasn't accurate, because I think there have been many adjournments, out of which only 2 were from his side.
No, that's factually incorrect. Several adjournments were taken by his side, and ultimately the application for bail was withdrawn before the Supreme Court, as I said. So that's factually correct. You can check it out on the website of the Supreme Court by checking the orders.
But again, in principle, is that something which, because it's in the public realm, it kind of becomes totemic of the principles of the Constitution? Do you think that there's a certain miscarriage of justice going on there?
I'll just step back from the particular case that you are mentioning and propound a general principle. The general principle of our law, and which must apply across the board, is that bail is the norm and jail is the exception.
Yeah.
Now, there are exceptions to this principle. For instance, if someone is likely to flee from justice or tamper with the witnesses, then you wouldn't grant that person bail. But if there's no likelihood of a criminal trial taking place at an early date, then you cannot have people incarcerated indefinitely.
Right.
And that is my own personal view.
So I would ask your personal view on this case, because again, as I said, it's in the national eye, and it's a JNU student in a protest, put away now for 5 years. It does in a way become a vehicle of very important public discussions and the principles of the Constitution. So just in a personal capacity now, what would your view be?
I'll tell you only one thing, Shoma, which is that, what you read in the social media is not necessarily what the state of the record is. And very often in the social media, a particular viewpoint is put forth to sort of create a sort of a public environment on a particular case. I'm not referring to this particular case on this. So you need to give this element of trust in the court and the court system, that courts don't decide cases on the basis of what is written in the newspapers or in the social media. You have to, at the end of it, look at the record of that particular case.
Sure.
And
because there's so much more to discuss, I'm just going to segue you away, but I'll ask you one more question on principle, is that in situations like this, where there is ambiguity, and like you said, it's in the public domain, maybe there's a skewed version of something, isn't it better then for the trial to begin, rather than someone to be incarcerated? And that's, of course, the norm where people are incarcerated many years without trial. But in this particular case, would you at least say the trial should begin?
Shoma, that is a serious problem of the administration of criminal justice in our country, and which is the inability of the prosecution to commence and pursue trials expeditiously. Sometimes, in some cases, the accused are responsible for it, not in all cases. But I think the lack of expedition in the disposal of trials poses a grave threat to personal liberty, because at the end of, say, a person is incarcerated even for 2 years or for a year or 3 years, and that person is ultimately acquitted, that means that person shouldn't have been in jail even for a single day.
Right.
So this is a problem. It's an endemic problem which the Indian system confronts. The answer to that problem is not just with the judiciary, because budgeting and infrastructure is not in the hands of the judiciary. The government has to fund the judiciary for better infrastructure with better budgeting. And the budgets for the Indian judiciary are woefully inadequate. So if we really want to emphasize the rule of law and look at India as a developed nation, which is really something which we all as citizens aspire to, rule of law is critical to the development of a society. And the only way you can perpetuate the rule of law is that if there is a respect for law. Right. And respect for law postulates this, just as we are developing.
There should be the infrastructure of law.
As we are developing the infrastructure in general in the country, we have to have adequate funding for the courts, more judges, better trained public prosecutors, which would ensure that these cases are taken up early. So much of the work in the criminal courts is entrusted to the police in the sense serving of summons, for instance. Now, if the summons are not served, the judges don't go and serve summons. The judiciary doesn't serve summons. This work is done by institutions and agencies outside the court. Right. So, it's the whole system has to be rethought of. Greater investment has to be made in the Indian judiciary to make it truly effective and to avoid the kind of problems which we both as citizens are agreed are a serious problem.
So Justice, I just saw the clock and there's so much to discuss and we're running out of time. I just want to share with the audience that Justice Chaudhury had made a specific request for me not to go into the Ayodhya judgment and the 370 judgment because there's been a lot of discussion about it
already. Just a little bit of a caveat. You called me Justice Chaudhury twice.
Sorry,
That's why I did.
See, you were talking about menstrual conditions. I was talking to a women's panel just yesterday, and we were talking about brain fog for women. So you've got to forgive me. I'm so sorry.
Not at all.
You can see, I was wishing I'm transposing myself into being a justice. It's like Justice Chaudhury. I'm so sorry.
I'd like to change seats, and maybe I could ask you a couple of questions then.
I'm so sorry.
Not at all. I mean, this is just.
Gosh, I'm visiting my doctor after this, But so I just shared that I'm not going to go into those two specific judgments because, you did ask that there's been enough discussion. But adjacent to that is something, again, which really matters for posterity, Justice Chandrachud, which is, which is that, the Ayodhya judgment played out as it is. It was a title suit, like you said. I'm not getting into that. Of course, there's been a lot of debate about it. But post that, there was this understanding that the 1991 places of worship would cut off all these big civilizational debates about history and, righting the wrongs of history. And there's been a lot of wrongs in history, and I think we need public discussion. We've had them even at Ignition, where there's truth and reconciliation. All of that is needed. But in terms of the judiciary, by you opening up the Gyanvapi mosque case, do you think that you have left in your legacy a very ambiguous judgment which could froth up again as a big cultural fault line in our society? How would you speak about what your sort of considerations were in that judgment?
I'll just answer it in just one sentence. I did not open up the Gyanvapi case. It's a suit which has been filed in the trial court in Uttar Pradesh. The suit is still pending. Certain interim orders were passed in that suit for conducting a survey. That was challenged before the Supreme Court. It is pending before the Supreme Court. So there's no question of me, either personally or as an institution, representative of my institution, opening up the case. What is the meaning of the Places of Worship Act? The Places of Worship Act, as I've said elsewhere, has an exception in the case of structures of archaeological importance. What is the implication of that? The Supreme Court is seized of it. I'm sure we'll hear from them at some point of time in the not too distant future. But, judges don't have the luxury of saying no to cases which are filed in a civil court. unless the case is specifically barred, or the case is barred by the principles of res judicata or is barred by limitation, you have to answer the case on merits. That case is still pending, so it's not as if that I've delivered a judgment. There is no judgment which has been delivered by me.
Yeah, but allowing
what happens is, and this is again a cause for concern, that a discussion, even an oral discussion in the court, is used to target an individual judge. And I've highlighted this and the grave dangers that it poses, that this is the problem in a deeply polarized society. A judge is not even allowed to ask a question which may appear to one segment of the polity as hostile to the position it is adopting. Well, it doesn't work that way. If we are truly a democracy, we must allow judges the space, we must allow lawyers the space. Freedom of speech and expression, even within the courtroom, is for different segments. That's how the ultimate synthesis of truth emerges.
Right. Gosh, I have so many. You mentioned the word freedom. I wanted to ask whether we actually need to rephrase parts of the Constitution which restrict freedom, because, hurt sentiment, law and order have become the default ways of curbing a citizen's right to dissent or to freedom of speech. And I would love your view on that. And there are a couple of others. So if we could quickly do a rapid fire.
In rapid fire.
Yeah.
I don't think there is a need to review the Constitution. We shouldn't review the Constitution. Constitutions are documents which are intended to last in eternity. What we need to revisit is the role of institutions which are working the Constitution. And how do you make them more effective?
Right. So, again, something which is in the contemporary realm is that Justice Shah, M.R. Shah, spoke of Prime Minister Modi as a hero and a model. And that created a lot of discussion in public life. Largely, again, because there's this kind of cultural idea that there has to be a separation of state and judiciary. And so even when you invited the Prime Minister to your house, there was a lot of discussion around it. So, it's not to suggest that there's anything further and deeper about it, but just in the realm of being seen to be at an arm's length from the executive, do you think it was wise for you to call the Prime Minister to your home? And Justice Shah's comments on the Prime Minister?
I don't want to talk about Justice Shah. He's been a colleague, and I don't think it's proper for me as a former judge to be commenting on what some other judge said in terms of his own assessment, assuming that he said that. I don't want to comment on him. Insofar as my role is concerned, the work which we do in relation to the government has to speak through our decisions. Assess my work as a judge. Assess the work where I have taken decisions. Some of them you have referred to, the electoral bonds case, the question as to whether the
Aadhaar case.
The Aadhaar case where I was a dissenter, the Bhima Koregaon case where I was a dissenter, the Aligarh Muslim case, Muslim University case where we reversed a judgment which was a judgment almost 30 or 40 years old. So look at and evaluate the performance of a judge through their judgments. The elementary niceties of high constitutional office, these should not really be allowed to occupy a public space just because you have particular views or likes or dislikes.
Right. So,
when the Chief Justice of India travels to the states, it's conventional for the Chief Minister of that state to come and meet the Chief Justice of India, come and have a cup of coffee with them in their room in the circuit house or wherever they are staying. Yeah. These are just elementary niceties of public office. We are a very mature democracy.
So just, as I said, I could go on for several more hours because there's so many things to discuss. But one, again, which is because it's part of what's happening a lot in society, is the curbing of dissent. So, and you've spoken strongly that that's the one freedom that the Constitution really protects, and it's a basic principle of being a democracy. So on issues of the National Security Act, the UAPA, it's kind of very routinely now invoked. And the most recent one was against Sonam Wangchuk. He's been somebody that's been very close to the government. His protests are really about the environment, about statehood for Ladakh. None of it seemed to be a national security issue or a UAPA issue, which is really for curbing terrorism, So in that case, and again using that as a symptom, do you think that these are times when the executive is overstepping or the police are overstepping, when courts really should step in and remind other arms of democracy what are the principles of democracy?
I would just differ with you only on one aspect. When you say that these are the times when the executive is
Of course,
overstepping.
I'm talking.
You look at the history of the last 75 years. You know, there is a tendency for all power to grow in terms of its dimensions, and that's why courts exist as public institutions, to exercise a check on the excess of executive and governmental power. And I believe that courts have to be extremely vigilant to ensure that, you know, this effort of centralizing or assuming power does not lead to a destruction of fundamental liberties of citizens. In fact, in the Bhima Koregaon dissent, I did mention in the course of the hearing that that dissent is the safety valve of democracy. And you must allow for dissent, because that allows for people to have lawful constitutional means of expressing themselves. Otherwise, there's a danger that people will resort to extra constitutional means. Right. So I do believe, speaking for myself, that dissent, not just in terms of its value in terms of the freedom of speech and expression, but as an essential element of democracy, is crucial. And therefore, the greater need for courts to be vigilant to any attempted encroachment on fundamental human liberties. And it's not something which is peculiar to our times. That has been so through the ages, and I think judges have to be therefore alive to the importance of the role that they discharge.
So just one last question, which is about the judiciary itself as an institution. And again, I'm hinging it on controversies, but it's really more a systemic thing. You know, there's again been a lot of rumbling, and why I asked about Justice Shah is that a lot of the liberty and civil rights cases have gone to him. And this is again about justice.
Oh no, that's again just anecdotal. That's completely wrong. You know, 21,000 odd cases, bail matters, were disposed of in my 2 years as a Chief Justice of India. One judge can't dispose of 21,000 cases. Every judge deals with cases dealing with bail and civil liberty. So please don't go by, you know, what is this sort of anecdotal stuff which comes in, you know, in coffee table conversations on the social media. It's not so.
Right, fair enough. And the last question, you know, is that recently again, you said something, and I'm again bringing this up because it's something which is of societal importance, is about accommodating faith. And, you know, I think liberals have gone very far in perhaps just being so scornful of it that there's a blowback. So I do want you to explain yourself in a way that everyone will understand. That I think you'd gone back to your village and somebody asked you, you know, how do you keep your equilibrium in this high and hot seat? And you had said even about the Ayodhya judgment that you did sort of seek a kind of, you know, a communion with the divine to help guide you in your decision making. And there was, of course, blowback and discussion about all of that as well. So how would you explain yourself, and why I'm asking you to explain yourself is in a way that people will understand the complexity of this and not necessarily hinge it that, you know, you made a Ayodhya judgment basis divine intervention. So this thing about keeping the principles of the Constitution and accommodating faith, what would you say?
Faith is a matter which is personal to each one of us. Faith is a matter which is personal to even judges. I'm a man of faith. Now, many people would have expected that I should keep quiet about it. I've been transparent about the fact that I'm a man of faith. I spend an hour every morning in prayer and meditation, in reflection. But equally, I'm very clear about my own faith and my philosophy, which is my faith teaches me to be even-handed between all religions. And ultimately, the test is, how do you work as a judge? Well, I pray, I have visited temples, but this is the same person who, when I was Chief Justice of the Allahabad High Court, there's a very significant dargah, very sacred dargah called Dewa Sharif at Barabanki. I was a repeated visitor to the Dewa Sharif dargah in Barabanki. When I go to Goa, I go to Old Goa and pray at the church in Goa. That's the kind of ethos which I learned as a young child in school, growing up in a cosmopolitan city like Mumbai. What I want to say is that judges work in areas of intense conflict. What is the way you keep your cool? Different people will have different ways to keep cool. I also do yoga. Now, I also believe in the value of robust exercise because you have to maintain your sense of calm, you have to maintain your sense of equilibrium. And the fact that I have given vent to this is by no means suggestive of the fact that a particular case, even the Ayodhya case, was decided on the basis of faith. Instead, I was only one member of a 5-judge bench. There were 5 judges who were part of the bench. And ultimately, you have to assess the judgment on the basis of the reasons which are attributed in that case, in that judgment, which is not really of a particular judge. It's a judgment of the court. Look at the reasons. It's a judgment which has applied principles of civil law or civil procedure and basic principles of law which have evolved over the past 100 or more years. So the judgment has been decided. You may criticize the view. That's everybody's right. Or you may agree with the view. That's your right again. But to say that, well, it's faith which has been the basis of the decision is not plainly correct because that's not how the judgment reads.
So, Justice, just because you said that about the Gyanvapi, that it's not a judgment. Why it's worrying, though, is that when you've allowed a survey to determine the character of that, structure, is it not just opening up something which, India has so much to do. There's so much to do. And like I said, in a cultural conversation, in public conversation, through governments, there can be discussion about the destruction of its colonial or even its, say its Mughal past, and cultures and societies have to make peace with it, discuss it, let anger out, etc. But through the judiciary, I'm just pushing you one last time on that do you think you've left the door open for another fault line to develop?
No, Shoma. First, it was not that we ordered the survey. The survey was ordered by the civil court, which is hearing the case. The survey was upheld by the Allahabad High Court. Now, when it came to the Supreme Court, and that nuance is very often lost, the Supreme Court, by the time the case came to us, the survey had been completed. We prevented an analysis of the carbon dating of the particular, the particular point in that structure. One of the things which was asked for was carbon dating, which had been allowed. We stayed that part of the direction. We said there shall be no carbon dating. Second, we also ensured that namaz in the mosque shall proceed without any hindrance. We directed the district collector of Varanasi to ensure that namaz takes place, that the place where, for instance, the wuzu is to take place in the mosque, that will also proceed unimpeded. Now, one segment of our polity, unfortunately, never really looks at the nuance in the case. That's not the way courts function. Courts have to draw a balance because courts are deeply aware of the fact that we do our work in a pluralistic, multi-religious, multicultural society, and drawing balances is the key to the judicial function. Now, when you go about drawing balances, it may not appease everyone, but so be it. That's part of the judicial function.
Thank you so much, Justice Chandrachud. I just wanted to share with the audience that one big thing that Justice Chandrachud has done is to really bring technology into the courts, to allow live streaming. He was just sharing with us that all judgments from 1947 are being translated into all Indian languages so that everyone can access it, understand it, make it easier. People can now not travel to the courts but do virtual conferencing. All of these are big steps in making justice democratic and accessible. I didn't talk about it because there's no debate on that.
Thank you.
Thank you very much,
Shoma.
Justice Chandrachud.
Thank you very much.
Thank you.